Morning. Tom used the word admirable. I think it's admirable that we have so many people here so early in the morning to listen to a presentation on healthcare reform. I'm very impressed. So just to give you a little more background on me, I'm an attorney, and I work for a national labor and employment law firm, Fischer and Phillips, and we focus on labor and employment law and how it impacts employers, all from the employer side. There's a few of us that focus on employee benefits. That's what I do. And as you might imagine, healthcare reform has been a big part of my life the last few years. I was telling some folks this morning, I was talking about this, giving presentations like this back before the act was passed, back when we had the Senate version and the House version, and there was some debate about where that was going to end up, and it all came crashing together back in March of 2010. So it's hard to believe that I've been doing this for 3.5+ years at this point. But my focus is on how healthcare reform is going to impact employers. And I think that's why everybody's here this morning, right? You're trying to figure out how this is going to impact your business. And that's what we're going to talk about this morning. We're going to focus on the key issues that could have the biggest economic impact on your business. Or if you already have a plan together and you're just trying to figure out how this is going to affect your plan, we're going to focus on the key issues that are going to impact the design of your plan. So here's how we're going to go through it today. The key issue for ag employers, and frankly any employer, is the mandate, right? We've all read about the mandate. Comes into effect next year in 2014. This is the item that's going to have the biggest impact on your business. Now, there's a few other things that I want to talk about which are related in some respects to the mandate, but the mandate is really the biggest issue, and that's the one we're really going to dig into deeply today. We're going to talk about the mechanics of how it works, because I think that's why a lot of you are here, is to understand exactly how it works, how it's going to impact your business. But before I get into the mandate, I want to talk about the big picture a little bit. Now, this may come as a surprise to many of you, but I stand in front of a lot of groups of employers like this, and a lot of employers aren't too pleased about healthcare reform. Right? You're here to understand how it works, how it's going to impact your business, but you're probably not entirely pleased that you have to spend your morning doing this. And so I talk to a lot of employers, a lot of my clients in groups like this, and the main focus is, how can I get out of this, right? There's got to be an exception. You have to be kidding me. It can't be this complex. Well, don't shoot the messenger, right? Hopefully nobody brought any of their fruit with them today. I'm going to tell you right now, it is complex, and it is a pain, and it is going to cost you money. A lot of folks were kind of waiting to figure out what to deal with this. First, until the Supreme Court ruling last summer. Some of you probably remember that. A lot of employers just said, look, I'm going to put this out of my mind until we see what the Supreme Court says, because the Supreme Court surely is going to bail me out of this. Well, we know that didn't happen, right? So then a lot of employers said, okay, but we still have the election, right? Mitt Romney is going to take care of this for me. We all know how that turned out as well. So we get past the election. My phone starts ringing off the hook. This is a reality, okay? Healthcare reform is a reality. It's not going to go away. The feds aren't going to push it out any further. They've had plenty of opportunities to do it. They've said they're not going to push it out. It's now time to figure it out, and that's why we're here again. But let's talk about that big picture for a moment, because again, the focus of a lot of employers is, how can I get out of this? Keep in mind, as we walk through the mechanics and you think about how can I get out of this, that the goal of healthcare reform is to get people covered. So when we look at all of these rules that are going to apply to you, keep in mind as you're looking for those exceptions, as you're looking for that way out, that the goal here is to get people covered. And employers play a big role in that. So when the government is looking from a regulatory standpoint at all these rules and how employers weave their way around them and weave their way through them, the overlying policy goal is to get people covered. And that's the lens through which the regulators are going to look at this. So keep that in mind when you're thinking about how you're going to deal with this with your business. Because the regulators, their view of the world is, look, the rules are the rules, and the policy here is to get people covered. So if you're getting aggressive, that's the policy standing behind it. You just have to keep that in mind. So again, talking about the big picture before we get into the weeds a little bit, I like to make sure that I just give an overview of kind of the tools in healthcare reform that serve this policy goal of getting people covered. Because I think you need to understand the big picture of how all of it fits together before you start digging into the employer piece. So I've listed here on the screen what I believe are the three primary tools. And it starts with the individual mandate. Most of you probably heard more than you care to hear about the individual mandate, right? This is what the Supreme Court was looking at back over the summer. Starting January 1, 2014, every individual in the United States will have to be covered by health insurance. If they're not covered, they're going to pay a penalty tax for the privilege of not having coverage. Now that penalty tax starts out pretty small next year. $95 for the year, or if greater, 1% of your income above the filing threshold. So a lot of people look at this and they say, you know what? All those young, healthy people that we want to get into the system, right, to help kind of subsidize everybody else, they're not going to buy coverage next year, right? It's a $95 tax. Maybe, maybe not. We'll have to see what happens. But what happens is that individual mandate tax ratchets up fairly quickly. By the time you get to 2016, a couple years in, it's $695 a head, or 2.5% of your income above the filing threshold. So by the time we get there, we're starting to talk about real money. No matter how young you are, no matter how healthy you are, you might just spend a couple $100 a month to buy some insurance rather than just paying a penalty tax into that big black hole of tax collection, right? And then let's remember, it's not going to stay there. It's going to be indexed to inflation. So at some point, the theory is this individual mandate is going to cause every individual in the United States to get coverage. They're not going to want to pay the tax. They're going to want to get something for their money. Some of them actually need the coverage, right? And so the theory is everybody's going to get covered. This is what we ended up with as an alternative to universal health care, right? If you want to get everybody covered, you can either give them the coverage, universal health care. That didn't work politically. You can put them in jail if they don't have coverage, right? Well, maybe you could. I don't know. We'll have to see what the Supreme Court says about that. Or you can basically penalize them for not buying coverage, the individual mandate. That's what we ended up with. So that's how this works from the individual side. Now from the employer side, that's where we're going to get into the weeds in a minute. Same concept. We get to January 1, 2014, and if you're a large employer subject to the mandate, you have to provide coverage or offer coverage to your full-time employees and their dependents. If you don't, you will pay a penalty tax for the privilege of not providing coverage to all of your full-time employees and their dependents. Again, we're going to get into the detail, but thinking about the big picture and how all of this fits together, there's a big role to be played here by employers. And again, you have the regulators in the background looking at that policy to get everybody covered. Last but not least, we have the health insurance exchanges. Or some of you may have read recently they changed the name to marketplaces, right? It's all about marketing, and somebody in HHS decided that a health insurance marketplace sounds a lot better than a health insurance exchange. People understand the concept of a states, and in some cases the feds for the state, are going to set up mechanisms for individuals and eventually some types of businesses to procure their insurance. But more importantly, these are the vehicles through which the government is going to provide subsidies for lower income individuals to buy their coverage. So if you're somebody who doesn't get coverage from their employer, or maybe you don't have a job, so you don't have employment-based coverage, and your income's in the right level, you'll be able to go to an insurance exchange, depending on the state you live in, buy your coverage, and to the extent you qualify for a government subsidy, basically you're going to net out what it costs you out of pocket because they're going to apply the subsidy towards the cost of the coverage. Now, the folks at MVP are going to talk about the exchanges in a lot more detail later, so that's all I'm going to say about it. But I wanted to talk about it briefly in the context of the big picture because that's how all of this fits together. You can see all the different angles. We have the mandate forcing everybody to buy coverage. We have the employers, in effect, being forced to stay in the game in some respects and continue providing coverage rather than dumping everybody out to the exchanges. And then we have the exchanges that come in and pick up the coverage for everybody else. So that's the big picture. And again, I can't emphasize enough, the policy goal here is to get everybody covered. There's no magic solution for ag employers. There's no blanket exception for ag employers. I talk to a lot of ag employers and they say, gosh, there's got to be an exception here. We are an industry that traditionally has not provided health benefits to large segments of our workforce, right? You have a large, low-paid workforce, and I don't know too many growers, too many farmers who voluntarily in the past have provided coverage to those workers. But now we have healthcare reform stepping in and in some cases forcing your hand and requiring you to provide coverage. And it's easy to sit back and say, well gosh, they couldn't have intended that. That's going to turn my business upside down. It's going to take those razor-thin margins that I already have, and it could be a deal breaker for my business. And I've talked to a lot of ag businesses and other businesses in similar situations like retail, hospitality, entertainment industry, where, again, these are industries with low-wage workforces that did not traditionally provide benefits. These are the industries that are affected most by health care reform, and agriculture is right at the top. There are no magic solutions. You're subject to, by and large, the same rules as every other employer in every other industry. So I could take out all the agricultural references that you'll hear today and give this same presentation to any other type of industry. So keep that in mind. There's a few little exceptions that we're going to talk about that are unique to your industry, but by and large, you're in the same boat as everybody else. All right, so I'm moving on to the main event, the employer mandate. Again, the basic concept is we get to January 1, 14, and you have a choice as a large employer. You can play or you can pay. You can provide benefits or you can pay a tax. I like to think of the mandate as a two-step process. The first step is figuring out whether the mandate applies to your business, whether or not you're a large employer. Now that's something that on its face sounds like it ought to be relatively easy, right? 50 or more employees, what's the big deal? Well, like anything related to health care reform or employee benefits in my experience, or the tax code, it's never as easy as it ought to be. It's a fairly complex analysis that you have to do to figure out whether you're a large employer subject to the mandate. And I want to spend some time walking through that process this morning because I think it's going to be important to a lot of the folks in this room. So again, step one, does the mandate apply? As I mentioned, it applies starting January 1, 2014 to large employers. So how do we define a large employer? Well, a large employer is an employer who, on average, employs 50 or more full-time employees, including full-time equivalents. So the first big question is, okay, what do they mean by full-time? Because let's face it, everybody has their own definition of full-time. You know, I work with employers where full-time is 40 hours a week. I work with employers where it's 25 hours a week. Depends on your business, Depends on your workforce. Throw out how you've defined full-time, because that doesn't matter for this purpose. For this purpose, you have to use the definition that's in the law. And the law says that you're full-time for health care reform purposes if you, on average, work at least 30 hours a week. Now, through regulations, the IRS has stepped in and said what that means is 130 hours a month. If you do the math, 30 times 4 1/3 weeks is 130 hours. That's where they came up with 130 hours. But what that means, when you look at it on a monthly basis, is somebody doesn't necessarily have to work at least 30 every week, right? They could work 20 one week and 60 another. As long as you end up over 130 in the month, you are a full-time employee as to that particular month. Now, there's another concept in here, and that's this concept of full-time equivalence. They didn't want employers to be able to stay under the radar by basically converting to a part-time workforce. That would be too easy, right? You have 55 employees that are full-time. You just take 10 of them and you convert them to part-time positions, and maybe you have 20 part-timers. Then you're under the threshold, right? Well, they thought of that when they wrote the law. And that's why this 50 or more test includes what they call full-time equivalence. And I'll talk about how you figure that out in just a moment. So here's how the test works. To figure out whether you're subject to the mandate in a particular year, you look to the prior year to determine whether or not you meet this 50 or more test. I have a question. Sure. Let me repeat the question so we can make sure everybody heard it. The question is, what about if you have multiple different operating companies? I'm going to summarize it a little bit, right? A lot of you probably work for businesses where it's not just one company. You know, maybe there are 3 or 4, maybe there are 2. They thought of that as well, right? It would be all too easy if you could take your 200 employee company and just divide it into 10 separate companies of 20, right? This concept, this rule, is applied on what they call a controlled group basis. Some of you in the room may have heard of this concept of the controlled group. It's largely a tax code concept that takes sufficiently related entities and treats them as one for various purposes. The simple example is you have a parent company, and maybe you have 5 operating companies under it, all 100% owned. Those are all going to be treated as a single employer, single controlled group. And for purposes of this 50 or more test, you're going to add them all up together to see whether you meet the test. Okay, that's the simple example. Another somewhat simple example, instead of a parent company and 5 operating companies, you just have 5 operating companies, but they're all owned by the same individual, 100%. Same thing. All 5 of those are going to be part of a controlled group and be treated as a single employer for purposes of this test. You're going to add them all together. Now, where it gets complicated is if you have related entities with common ownership, but not necessarily 100% common ownership. That's where it starts to get interesting. So in the parent-subsidiary concept, if the subsidiary is at least 80% owned by the parent, then it's treated as the same employer. If you get the ownership below 80%, the subsidiary may be treated as a different employer. In the concept where there is no parent company and you just have separate operating companies, if you have different ownership for each company, you may be able to separate them out. Basically, if one person owns at least 80% of each company, well, then you know they're all part of the same group, and you're going to count them together. If you can get the common ownership among the 5 operating companies in my example underneath the 80% threshold, you may, and I emphasize may, be able to separate them out so that they're treated separately under this rule. Now, the controlled group rules are very complex rules. These rules are not new. They've been in the tax code for a long time because this concept of treating related entities as the same entity is not a new concept. It applies in a lot of different contexts. I can't stand up here and give you every different scenario about how to break up your companies and make them separate by bringing in outside ownership. I will tell you this, though. I have sat down with a lot of clients to figure out whether that can be done. And in most cases, it can't be done. Because in order to truly separate out multiple companies, you have to bring in true blue third-party ownership. You can't simply take 25% of your company and put it in your wife's name, or put it in your brother's name, or your son's name. It's not that simple. There are a lot of traps in the rules. For example, there are situations where families, basically family ownership is squished together and treated as the same owner. I have a lot of clients that say, well, I have some really good managers. I'll just figure out a way to get 5% of my company in the hands of my top 5 managers. Do it that way. Well, that may not work either, because the rules have some provisions that say in some cases, and if an employee owns a piece of the company, you disregard it so that in effect it doesn't matter. So what I always tell a room like this, if I'm not sitting down with actual data, because this stuff's just too complex to do on a broad basis, is you have to be careful. If one of your potential strategies is to break your company up, you need to sit down with your lawyer or your accountant or whoever it is you would go to for this type of advice and have them very carefully look at whether your companies can be broken up. And what I have found, again, most of the time when I sit down with a client to do this, is it's the tail wagging the dog, right? It'd be great to be able to do it, to break yourself into multiple companies, but by the time you have to bring in actual outside ownership, you're talking about bringing up a lot of interesting business issues, and then at some point you back up out of the weeds and you say, gosh, is it really worth it, right? Is it really worth bringing in outside owners to break my companies up? And a lot of times it's not. So it is a strategy, but you have to do it carefully. You need to make sure that you're getting some good professional advice about how to do it, and it's not always going to work. That's about as much as I can tell you in a room like this. Questions?
I have a question. In terms of productivity, employees, if you have employees.
Yes. Okay. Let me repeat the question. We're a half hour in, and the H2As have come up. You beat me to the punch on that one. I'm going to call them guest workers because who knows what they're going to be called, around the corner. Guest workers are employees just like anyone else. H2As are workers like anyone else. I have found there's a big misconception in the industry that somehow H2As, guest workers, don't count. That's not true. Remember the individual mandate we mentioned? That applies to every U.S. citizen and anybody who is lawfully present in the United States. If you're here on an H2A, you are lawfully present in the United States. Technically, you have an obligation like any other individual in the United States to have coverage, and likewise, you count as an employee, just like any other individual when it comes to the employer mandate. So there is no exclusion for H2As. If you look at the statute, and this is, when you ask the IRS to create an exception, the first thing they do is they look at the statute and they say, is there room in the statute for us to do this by regulation? Because the statute certainly doesn't create an exception for H2As. And if you look at the statute, there's no room. I mean, there's nothing there for the IRS or anyone else to point to create a blanket exception for H2As. So maybe we'll get not an actual exception, but some rules that'll help you to deal with H2As and the manner in which you employ them. But by and large, you should assume that if you're employing H2As, guest workers, they're going to count like anyone else. Now, we'll talk a little bit down the road about how the manner in which you employ them may allow you to navigate through the rules so that they're not as much of a burden as they might otherwise be. but they count as an employee for all of these purposes that we're going to talk about today. Question?
I was curious, do these rules apply to nonprofit as well as for-profit?
Good question. Do the rules apply to not-for-profits? Yes. All of these rules apply to not-for-profits, governments, state and local. Okay, there are no exceptions. It's, I've been doing this for a long time, and an employee benefits practice is a regulatory practice. There's a formula that you usually see when new rules come out or new statutes are enacted, and there are usually exceptions for certain types of groups, not-for-profits, government, sometimes industry-specific. A lot of times there are exceptions for collectively bargained employees. None of that in healthcare reform. Healthcare reform is an equal opportunity problem, depending, regardless of what type of entity you are, regardless of what type of employer you are. So keep that in mind. So let's talk about this 50 or more test. As I was saying before we started taking some of the questions, to determine whether you're a 50 or more employer in a particular year, you look back to the prior year, and the test is, did you on average on business days during that prior year employ 50 or more full-time employees and full-time equivalents? Well, the IRS looked at this and said, well, gosh, to have somebody go and look at each business day of the year, that could be difficult, particularly when you have a fluctuating workforce, like I know a lot of you do in this room. So they didn't completely take away the complexity, but they said, okay, let's look at it on a month-by-month basis. So here's what you would do, and I'm just going to use 2013 for 2014. So here's what you would do for 2013 to determine whether or not you're a large employer for 2014. And you would do this each year to look to see whether you're a large employer for the following year. You're going to take each month of the year, and the first thing you're going to do is you're going to add up the number of full-time employees that you employed during that month. Well, that's the folks that worked at least 130 hours during the month. So you look at your payroll records, figure out how many people worked at least 130 hours. Each of them counts as one full-time employee. Next, you're going to take each employee that you employed during that month who didn't work at least 130 hours, and you're going to add up all the hours for those employees. So you may have had some employees that work 10 hours a week, 20 hours a week. Basically, you're just going to add up all the hours. You're going to take all those hours and divide them by 120. And that's going to give you a number of full-time equivalents. So let's say you had 10 employees who worked 120 hours during the month. 10 times 120 is 1,200. Divided by 120 gets you right back to 10. 10 full-time equivalents. Now that's an easy example, but obviously it could be a lot more complex. You might have 100 employees who worked 85 hours during the month, and another 25 that worked 100 hours during the month. You add up all those hours and you divide it by 120. Now remember, you're only adding up the hours of the people who didn't work at least 130. All right? So you're dividing your workforce into those that worked at least 130, add up the number. Everybody else goes over here, you add up their hours, you divide it by 120. Now you may be scratching your head and saying, why am I dividing it by 120? That's not a mistake, okay? I've been doing this long enough, I haven't made a mistake. I can't tell you why they decided to do that. It's not uncommon for the IRS in tests like this to add in some margin for error, let's say. And they decided that when you're figuring out full-time equivalents, basically they're going to use 120 as a number instead of 130. That's just the way the test works. Don't shoot the messenger. So, you're going to do this for each month of the year. This is going to be a lot of fun, okay? What I just described, let's call that January. You're going to do that for February. You're going to do it for March, etc. For each month of the year. Now, for those of you who have varying workforces throughout the year, that's good, right? Because you're going to have months where your average is a lot lower than it is in other months. You're going to add up all of the numbers that you come to for each month, and you're going to divide it by 12. If it's 50 or more, you're subject to the mandate in the following year. If it's less than 50, you're not. Now, if you really want to get into the weeds, because I get this question more than you might expect, people say, well, what do you do with the fractions, right? If you add up a bunch of hours and you divide it by 120, you might get 9.7. Yes, you might get 9.7. And the rule is that you leave the fractions in for each month. Now, when you add them up, it has to be 50 or more, including the fractions. So if you end up at 49.8, guess what? That's not 50 or more. So you're not, in effect, rounding up for your yearly number. But on the month-by-month determinations, you leave the fractions in. Don't ask me how many decimal points to go to. They didn't specify that. My recommendation there would be to go to two decimal points. So you might have 9.78 employees in January, but in any event, you add it all up, it has to be 50 or more on average to count. See this thing on the bottom? You guys beat me to the punch on the controlled group issue. That was going to be my punchline at the end of this. Because again, I know a lot of you work for businesses where there are multiple operating companies. Don't forget that controlled group issue. That's probably the number one thing. Before you even start adding up employees each month, you need to sit down and figure out how many companies do I have and which ones are treated as one single employer for purposes of this test. Then you move into adding up the number of employees for each month to do this test. All right. Remember I said there's no free pass for the ag industry? There are a couple of exceptions that may help the ag industry. One of those is called the seasonal worker exception. Now you can thank Congress for this. They put this right in the statute. We didn't have to rely on the IRS to come up with it. But this is an exception that may be useful for some ag employers. Here's how it works. If you're doing this average, and in most cases you're well under 50 employees, maybe you have a year-round staff of 20, 25 employees, but you bulk up for harvest or other parts of the year where you need to bulk up your workforce. This seasonal work section says, look, if you bulk up above 50 for 120 days or fewer during the year, and that's the only reason that you end up averaging over 50 for the year, then you won't be treated as a large employer. But that bulking up can only be 120 days or fewer during the year. The IRS has said, okay, we'll treat 4 months as 120 days. So if for 4 months or less you're bulking up above 50, and the reason you bulk up is you're using seasonal workers, we have to talk about that in just a moment, then you won't be treated as a large employer even if the times that you bulk up during that short period cause you to exceed 50 on average during the year. Now, let me talk about what a seasonal employee is, or seasonal worker is, before I take some questions on this one, because that might be what some of you want to talk about. I've included in the slides the regulatory definition that we have right now of a seasonal worker. And the first part of it that's not underlined is sort of a circular definition. It's somebody that works on a seasonal basis. Well, that's helpful. The underlined part that I think is good for ag employers, because it recognizes that somebody may be a seasonal worker but yet work most of the year. And it specifically references the ag industry. I represent a lot of ag employers in the South where there are year-round operations, right? You're moving people from place to place, or you're in Florida where you can run a year-round operation right where you are. So a lot of folks that you might think of as seasonal workers, H-2As or anyone else, they actually work the entire year, and it's kind of hard to get your head around that you could work the entire year but still be treated as a seasonal worker. Well, it's good news for the ag industry because they've said, look, they've recognized that even if somebody works a good part of the year, they can still be a seasonal worker if they're doing work that is seasonal work. And again, they've specifically called out the ag industry as a type of industry where there is seasonal work. So this is good news. So remember that 50 or more exception, 120 days or fewer. So if you depending on how your seasons work and when you're bulking up, that's a relatively short period of time. It's less than a third of the year that you would bulk up above 50. And the only reason you're bulking up above 50 to take advantage of that exception is seasonal workers. You're bringing in seasonal workers who are not there for the majority of the year. So let me take a few questions if there are any more on this before I move on to the next topic. Sure.
A seasonal worker that every 2 days is not considered a seasonal worker.
No, that's not true. The question is somebody who works more than 120 days a seasonal worker? No, somebody could work for you all year, but if they're doing seasonal work, they're considered a seasonal worker. The 120-day rule is if the only reason you're bulking up above 50 is 120 days or less during the year, and it's because of seasonal workers. You might have regular seasonal workers that are with you 300 days a year, but you have an extra number of seasonal workers during this 120-day period. That's where you might be able to take exception or make use of this rule. I will tell you this, though. I've looked at this rule for a lot of agricultural employers, and any ag employer of any size that has an operation that goes either most of the year or half of the year or 3/4 of the year is probably not going to be able to make use of this rule because of that 120-day limit. It's also going to depend on how big your regular staff is. I mean, if you have 55, 60 full-time employees year-round, well, then forget about this rule. It's not going to help you. It only helps you if you're normally under 50, but you bulk up for that short period above 50 with seasonal workers. A couple more questions, and then I'm going to keep moving on. Again, we'll have time for lots of questions later as well. Consecutive, right? Yeah. Yeah. Surprisingly, the IRS has said that 120 days or the 4 months, depending on how you decide to look at it, does not have to be consecutive. So you may bulk up 2 times during the year for 50 days each, let's say. But it can't be any more than 120 days that you're going above 50. I'm going to take one more question, and then we're going to move on. I'm so glad you asked that. So the question is, does it have to be a farm worker, right? Because, I mean, my classic example up here is like a harvest worker, right? It doesn't have to be, but whoever you're designating as a seasonal worker has to fit into that definition, which means, yeah, retail is one of the industries that has been called out as an industry that typically does employ seasonal workers. And of course, what they have in mind is the holiday retail worker. But if because of your business you have some retail arm that's seasonal, maybe it's just during the summer, yeah, then certainly as long as those folks are doing seasonal work, you could count them as a seasonal worker. It doesn't have to be a farm worker. All right, I know there's lots of questions, but I want to make sure I get through everything because there's going to be lots of questions on some of these other slides as well. I've already mentioned a few of these things. Keep in mind that this seasonal worker exception is not just a blanket exception for the ag industry. I've seen a lot of misconceptions about that in your industry. Oh, there's an exception for us. It's this seasonal worker thing. No, it's only It's only an exception for you if you fit the rule. And you've all just lived through how complex the rule is, right? You have to sit down and look at it. It's very mechanical. So it may be helpful for you, but don't take it as a blanket exception for the ag industry and just kind of move on. And as I mentioned, in my experience, that exception is not going to be very helpful, particularly for growers that have a year-round season. Now, I want to mention one more exception to the rule, and this is a special exception that applies just for 2013 to 2014. Now, remember, I said if you want to figure out if you're a large employer for 2014, you look at your employee counts during 2013, right? You do that month-by-month determination, and you divide it by 12. And that's how it's going to work from here on out. Every year, you're going to have to add it up, figure out whether you're a large employer in the next year. There's a special rule for 2014, though, and that rule says that for purposes of figuring out whether you're a large employer in 2014, instead of having to use the whole year, all 12 months in 2013, you can use any 6-month period during 2013. Now, this one has to be a continuous 6-month period instead of the entire year. Now, that may be very good news for a lot of people in this room, because I have a feeling that some of you can pick a particular 6-month continuous period during 2013 where your staffing is about as low as it could possibly get, right? If you have a seasonal operation, you can basically skew the number and take advantage of this rule for 2014. But just remember, this is only a special rule for this year. When you're looking at 2014 to see if you're a large employer in 2015, you're going to have to use every single month in the year. The reason the IRS did this, they didn't come out with all the regulations that defined all of this until early January. And they were concerned, because the IRS does actually have some concern for employers once in a while. They were concerned that employers weren't ready. If you get all the information in January, first of all, it's going to take you 2 months to figure it out. It took me a month, and I do this for a living. And it would be too late for you to basically manage your business in the way you want to manage it, either under or over the 50. So that's why they said, okay, special one-time rule for 2013, you only have to use a 6-month period. It has to be a continuous 6-month period. So in any event, I have a feeling that that rule may be more useful, at least for this one time, to folks in this room than the seasonal worker exception. All right. We've spent a lot of time talking about how to determine whether you're a large employer. And I know everybody probably still has some questions, and again, we'll get to those throughout the day. But that's just step one. Remember, step two is, okay, you are a large employer. What does it mean? How's it going to impact your business? One more thing I want to mention about step one before I move on to step two. I talk to a lot of crowds like this, and I see people scratching down the notes, and again, it's a complex test that you have to do to figure out whether you're 50 or more. Keep in mind, if you're a large operation, you have 75 full-time employees on average at any given time. You don't have to worry about that. There's no reason to sit down and add up the months and everything else. You're a large employer. Forget about it. If you're a small employer, maybe you only have 20 full-time employees at any given time. No need to do the math, right? You know the average is going to come out under 50. It's the folks that are in that sort of 40 to 60 range who might have a lot of part-timers, who might staff up to 300 during certain parts of the year. Those are the folks that need to sit down and run the numbers. So if you're looking at all of this saying, gosh, this is going to be a lot of work, think about which bucket you fit in. Are you large no matter what? Are you small no matter what? Or are you in that range where you are going to have to actually worry about this? All right, because I think some of you in this room are going to be on either extreme and probably are going to be a little more focused on this step two. So step two, you thought step one was fun. Wait till we get to step 2. So what we're talking about here is somebody who's a large employer. Now, some of you may know that you're not going to fit into that status. Don't ignore the rest of this, though, because you may get there someday. Or you may be on the cusp of it, and you may need to know what it's going to mean if you bulk up above 50 and become a large employer. So again, we're talking about an employer that's over 50, so they know they're going to be subject to the mandate January 1, 2014. Again, the choice is to play or pay. Play is to provide benefits. Pay is to pay the penalty tax for not providing benefits. I want to talk first about what it means to play, to provide the benefits, because this is what a lot of employers are going to do. It's what a lot of them do today, and it's what a lot of them will choose to do in the future. So, to play means that you have to offer coverage to all of your full-time employees and their dependents. That's the first step of playing. Offer coverage to all full-time employees and their dependents. Now, remember, in step 1, we talked a lot about full-time equivalents, right? These are your part-timers. It's important to remember that once you get to step 2, those part-timers, in effect, don't matter. They count for purposes of figuring out whether you're a large employer, but once you get there, your only obligation is to full-time employees and their dependents. You don't have to offer coverage to somebody who doesn't qualify as a full-time employee. This is why you've probably read in the paper, like I have, that there are a lot of employers that are figuring out ways to run their businesses with fewer full-time employees and more part-time employees. The extreme example I like to use is, you can be IBM. And if you have 10 full-time employees and 100,000 people who work 28 hours a week, guess what? Healthcare reform is not such a big deal for you, because you don't have to provide coverage or pay a penalty for all those people who work 28 hours a week. They're a part-time employee. Your only obligation is as to full-timers. Now, in your industry, based upon most of the clients that I work with, it's not necessarily an option to restaff your operation with part-time employees. Now, for some of you, maybe that's something you can do, but by and large in the ag industry, I'm told that that's really not feasible to take these folks that are working 50 or 60 hours or 80 or whatever it is and try to restaff that with 4 or 5 people working 20 hours a week. But I can tell you in other industries, that's exactly what's happening. The days of the 32-hour-a-week waiter are gone. Waiters are going to work 28 hours a week or less from here on out. There's just no reason to employ somebody in that type of position for more than 30 hours. So just keep in mind that the obligation to offer coverage is only to your full-time employees and their dependents.
Could you explain what a full-time employee is? You said 28 hours or less. I've got 200 that work 7 months a year.
Sure. The way the statute works, full-time status is determined on a month-by-month basis. Earlier, remember, I said that the monthly equivalent of that 30 hours a week is 130 hours, okay? So you're going to look at it basically on a month-by-month basis, and whoever's full-time is who you're going to have this obligation to offer coverage to. So if you have somebody work 7 months of the year, for the 7 months that they're working for you, if they're full-time, you have this obligation to either play or pay. All right? So you're not looking at it over the whole year necessarily. Now, a little bit later, we're going to get into this, how you figure out who's full-time. So let me just put that aside for a minute. But the basic concept is, remember, 130 hours a month. So you have to offer coverage to all full-time employees and their dependents. And the coverage has to be both adequate and affordable. So let's talk about what that means. For coverage to be adequate, it has to cover what they call minimum value. Minimum value is something that is determined on an actuarial basis. Any of you ever worked with an actuary? It's fun stuff. So if you looked at a plan, let's just take an off-the-shelf insurance plan that you bought for your employees, and you take into account all the cost sharing that goes into a plan, copays, deductibles, other out-of-pocket costs that people have to bear when they're using the coverage. The plan, on an actuarial basis, has to cover at least 60% of the cost of benefits. Now, we're not talking about premiums. Put premiums aside for a minute. This is just, once you buy the plan, what kind of benefits do you get out of it when you use it? The plan on an actuarial basis has to cover at least 60% of the cost of benefits. Now, I'm no actuary, but I'm told that even your typical high-deductible health plan that's out there on the market today, where people are coming out of pocket a fair amount, several $1,000s for the first part of their benefits, will satisfy this 60% standard. This is not, in the world of insurance plans, this is not necessarily a super rich plan, 60% of the benefits. So what does that mean to you? Well, I don't think it's going to be difficult for most employers to provide a plan to their full-time employees that's adequate. I think that by and large, most, if not all, of the insurance products that will be out there on the market for you to buy are going to meet this standard. And so I don't think that the adequacy aspect of the mandate is going to be a big deal. It's the second piece that is potentially the big deal for this group. And so I want to move on to that. What does it mean for the coverage to be affordable? Let's assume you're going to buy an insurance product, or you're going to have a self-insured plan that meets that minimum value standard. Now you have to look at it and say, okay, it has to be affordable for my employees. The coverage is affordable if the employee cost of premiums for employee-only coverage does not exceed 9.5% of the employee's household income. I hear the murmurs in the crowd. I'm going to get to the details, so just hang on a second. The employee premium cost for employee-only coverage cannot exceed 9.5% of household income. So when they wrote health care reform, they didn't say, okay, the employer has to contribute X. You know, they didn't express it in terms of a minimum subsidy. What does the employer have to cover? You have to back into that by looking at the maximum amount that an employee can be made to pay. That maximum amount is 9.5% of their household income. Now, a lot of you are looking at me right now saying, how the heck do I know what my employee's household income is? Right? And my answer is, you don't. Not only that, there's no mechanism for you to find out what it is. You could ask, but I have a feeling there's a fair number of employees who don't want you to know what their household income is, right? They might have a working spouse, they might have a second job, there's any number of things that could increase their household income beyond what you pay them. But that's the rule. I mean, I'm sure this sounded like a great idea in the basement of Congress in the dark of night when they drafted the statute, but nobody who was involved in that process really thought about how this was going to work in the real world, right? You don't know what your employee's household income is. So the IRS has come up with some ways to help you with that. The IRS recognizes, again, they feel the pain of employers from time to time. They recognize that you don't know what your employee's household income is. So if they've said, okay, you can base this affordability requirement on one of three safe harbors. And I always have to bite my tongue when I use the word safe harbor, because really what we have is the IRS coming to you, the employer, and saying, we'll let you use a lower number, right? We'll let you use a number that you know that in all likelihood is much less than household income, but at least it's a number that you know, and there is some value in certainty, if you will, as an employer. So here's what they've said. instead of household income, you can use one of these three safe harbors. Number one, you can use W-2 income. You know exactly what your employees, what you pay your employees. You know what their W-2 income is. The problem is it's current year W-2 income. So if you set your premiums so they don't exceed 9.5% of somebody's W-2 income, and their income goes down during the year, you might get to the end of the year having charged them 10.5%, right? If their hours go down, if their rate of pay goes down, and there are a number of things that could happen that could change what their W-2 income is. So I don't know that this safe harbor is going to be entirely helpful to employers unless you're going to monitor it throughout the year. And if you have employees who are working less or being paid less, you're going to adjust how much you're charging them for coverage to make sure that you end up at the end of the year under this 9.5% threshold. The other, another safe harbor that they've come up with is what they call the rate of pay safe harbor. This one's good for salaried employees, and it's sort of logical. They've said, look, if you have a salaried employee, you can take their annual salary and break it into a monthly salary, and as long as you're not charging them more than 9.5% of that monthly salary, then your coverage is affordable. It's a little more complicated with hourly employees. For an hourly employee, you take their hourly rate of pay and forget about how much you're actually paying them during the month. You're going to multiply it by 130. Whatever that comes to, you can charge them at least 9.5% of that, and your coverage will be affordable. So you have somebody making $10 an hour, it's $1,300 times 9.5%. Now, they may actually be working 250 hours during the year, which means if you use the W-2 income, you could use a better number. But if you want the certainty of the rate of pay safe harbor, you can only take those hourly rates and multiply them by 130. Now, the last one, the last safe harbor, is probably the most helpful to employers from an administrative standpoint, but it may also be the most costly for employers. This one's called the Federal Poverty Line Safe Harbor. What they've said is if you look at the federal poverty line for a single individual, as long as you don't charge somebody more than 9.5% of that, your coverage will be affordable. So if you take the current federal poverty line for a single individual and you do the math, that comes out to $90.97 a month, kind of rounding up some pennies if any of you have seen it slightly different. So what does this tell you if you're an employer? Well, as long as your employees don't have to spend more than $90.97 a month towards their share of the premium for employee-only coverage, your coverage will be affordable. You don't have to get into this business of figuring out what their household income is and how much they make. It's basically a bright line, $90.97. Now, obviously, that number is going to change in the future. In all likelihood, it's going to go up. Usually, the poverty line goes up with inflation each year. But right now, just to get a feel for it, $90.97. So let's take an example, because for me, I have to have an example to get my head around this. Let's take a $30,000 a year employee. And just so I can do the math in my head, I'm going to round it to 10%. So let's take that $30,000 a year employee. They cannot spend more than $3,000 to buy employee-only coverage for the year. If you do the math, that's $250 a month. So an employee who makes $30,000 a year can be asked to contribute up to $250 a month towards employee-only coverage, and the coverage will still be affordable. So you take a policy, out where I'm from, if probably the cheapest policy you can get in the group setting for employers, your employee-only coverage is going to be about $350 a month. So if you look at my example for that $30,000 a year employee, you can have that employee pay $250 a month, the employer is going to pay the other $100 in that example. So to figure out how much this is going to cost you, because ultimately that's what you care about, you have to do all this math and kind of back into it. In my example, $100 a month for a $30,000 a year employee. Now remember, you're going to have some employees that are $18,000 a year employees, right? So it's going to start to shrink that amount that the employee can pay out of pocket, which is therefore going to increase the amount that the employer's going to pay. But that $30,000 example gives you something to think about. Did I have a question? Yes. Yeah. The question is, will that be an employer deduction? Absolutely. Any dollar that you spend subsidizing health coverage for your employees is a tax-deductible dollar if you're a for-profit. Oh, you're talking about the 250. Yeah, no. Yeah, absolutely. If the employee decides to sign up for coverage, again, using my example, that $250 a month would be taken out of their paycheck, but the 100 comes out of the employer's pocket. Question?
Can you offer multiple health care plans?
I'm so glad you asked that. I was going to get to that next. The question is, can you offer multiple health plans? Absolutely. The rule is that you have to have at least one coverage option that meets these requirements. You can have as many other coverage options as you want beyond that, and employees can basically buy up for that coverage. So, and there's one more thing I want to mention. This is for employee-only coverage. For those of you who have plans in place today, I have a feeling that you have other coverage options under your plan: employee plus spouse, employee plus family, dependents. The subsidy requirement we're talking about today is for the employee-only option. If it costs $350 a month for employee-only coverage and $1,200 a month for family coverage, you can make the employees buy up basically the difference if they want to buy family coverage. You are not required under health care reform to subsidize anything other than employee-only coverage. Likewise, if you have different options, a lot of employers will offer, an HMO, a PPO, and a couple of different, maybe a rich plan or a cheap plan, that kind of thing. You just have to have one option that meets these requirements, and then you can have as many of buy-up options, if you will, where you can make a business decision like you do today. How much am I going to subsidize for that expensive PPO? Maybe it's nothing. Maybe you tell the employee, my contribution is X, and if you want this other stuff, you just have to pay the full difference. You certainly can do that, and a lot of employers will do that.
What if you have an insurance carrier that is requiring for their underwriting guidelines to be paid at least 50%?
Okay, great question. What if your insurance carrier requires that you subsidize at least 50%? Well, you might want to find another insurance carrier. No, absolutely. And actually, I'm gonna hope that the folks at MVP might talk about this a little bit. I'll give you my 2 cents on it, and then this afternoon, hopefully they can address this as well. But absolutely, a lot of carriers have a minimum subsidy requirement. And the big question right now is whether the carriers are going to relax those standards, keeping in mind this entire new population of folks that are going to come in where employers are going to want to provide that minimum subsidy. That's a big question, and at least in my area of the country, I'm told by all the professionals that I work with that we don't know yet what the carriers are going to do with that. There's a lot of unknowns about the insurance products and what the carriers are going to do with it, but that's an issue because obviously you have to meet your contractual requirements under your policy along with all of these legal requirements.
In your previous slide, it said that we have to provide it for full-time employees and their dependents.
Yes. Yes, so I just mentioned that the subsidy requirement is for employee-only coverage. This is where there's a little bit of disconnect in the law. You still have to offer coverage to the dependents. You just don't have any minimum subsidy requirement for them. Okay? So again, you can make them buy up, but make no mistake, you have to offer it. You can't just have an employee-only option. Now, there was an interesting thing in these January regulations that came out from IRS. They said, you know what? The statute says full-time employees and dependents. It doesn't say anything about spouses. So you are not technically required to offer coverage to an employee's spouse. Now, I've been doing this for years. I've never seen a plan that offered coverage to dependents but not spouses. Never seen it. I mean, I'm sure in the history of the world somebody's done it. But we may actually see that in the future. You might see group products that are just, sort of healthcare reform minimum requirement, just the employee and the dependents, but no spousal coverage. The theory being the spouse can go to their own employer, or they can go to the exchange, that type of thing. But make no mistake, you're required to offer coverage to dependents, but you do not have to subsidize it in any fashion.
Okay, how do you know? The wife works at one place, you work at another place. How do you know who's got to pay for this?
The question is, the wife works one place, the husband works one place. How do you know who has to pay for it? All you care about is your employee. That's all that matters. Your obligation as an employer is to offer coverage that meets these requirements. If an employee decides not to take that coverage, not your problem. And they will not expose you to a penalty. That is a key aspect of this. Your requirement is not to make sure they get the coverage. It's to offer coverage that meets these requirements. And I got to tell you, I talk to a lot of employers in your industry, and they say, look, it doesn't matter how cheap this coverage is. Most of these folks are not going to buy it. They're not going to spend $90.97 a paycheck or whatever it comes out to be to buy the coverage. And the answer is, that's not your problem, okay? Some of them may choose to go without it. Some of them may get coverage through their spouse. All you have to do is make sure that you offer the coverage. Now, since somebody brought up the insurance question, I'll raise you one there. Some insurance products have minimum coverage requirements, right? If you're going to buy a group policy, you have to cover at least, X percent, 50%, 75% of your workforce. So great, it's going to be too expensive, so a lot of people aren't going to take it, but then I'm not going to be able to meet my insurance product requirements. My answer to that is, we don't know what the carriers are going to do with that just yet. I think carriers are going to have to recognize that when you expand the pool, it may no longer be realistic that 50% of the people are going to sign up or that 75% of the people are sign up. So my guess is that we're going to see some of those requirements relax, but I don't know. That's a contractual requirement that you deal with the carrier. So that's another something that we'll have to see. Okay, a couple more questions. Who decides what's a dependent? Well, the law, and it's a tax dependent. It's a IRS code 152 dependent. So if it would count as a dependent for tax purposes, again, not spouse but dependent, that's what a dependent is. And remember a few years back when healthcare reform was put in place, that definition of dependent got expanded, right? Children up to age 26, those are all dependents.
On the 9.5% or the $90, if that deduction goes below minimum wage, how does that affect?
Oh, okay, so the question is, what if somebody decides to sign up, they pay their $90.97, but that would take their pay below minimum wage? It doesn't matter, because this is sort of an after minimum wage deduction, okay? It's an elective deduction. I practice out in California where employment litigation is a sport, okay? And there are very strict rules in California, as in a lot of other states, about wage deductions. This is one of those deductions that's 100% voluntary, because they're going to fill out a piece of paper and say, yes, take $90.97 out of my check. Doesn't matter what that would do to the net, as far as minimum wage.
So the individual mandates only come into play on the employer side, so if an employee finds themselves in this scenario, aren't they against the individual mandate?
Yeah, make no mistake that if an employee decides not to take your coverage, it's too expensive, they're young, healthy, they don't want it, then it's between them and the IRS, the individual mandate, right? But keep in mind this, number one, the individual mandate penalty is relatively low next year, a lot cheaper than $90.97 a month, and the individual mandate penalty is collected when you file your tax return. Now, this may come as a big surprise to some of you, but some of your employees don't file their tax returns. Okay? And if you don't file your tax return, ask yourself whether you're going to actually pay that penalty. I mean, obviously, it may eventually catch up, but it's like anything else, right? So rest assured, there are some employees that won't understand the mandate, won't know about it, won't care about it. And they're not going to take your coverage, and they're going to take their chances on the mandate like anything else. At this point in the program, it's common where I get a lot of employers who are just kind of shaking their heads saying, you know what, that's it, I'm done. All right? This is way too complicated. Tell me what the penalty is, and I'll pay it. Now, it depends on which articles you read and which studies you believe as to whether a lot of employers are going to do that or not. If you believe that employers are going to wholesale stop providing coverage, you can find the study that says that. You can also find the study that says just the opposite. I don't think anybody really knows what employers are going to do. One lawyer's experience, you can rest assured there are a lot of employers going to pay this penalty. Most of them, though, are in that sort of 60 to 150 range. That's my experience. They're looking at it and just saying it's not worth it. With employers that are kind of above that 150 range who are already providing coverage, my experience is the same as those studies that say employers aren't going to go out and just wholesale drop coverage. They're going to wait and see what happens, see what the exchanges look like, and keep providing it for a while. But you do have a choice. So I want to talk about the other side of the choice because that's important for everybody else. If you decide not to play, meaning you don't offer coverage to all full-time employees and their dependents, you will pay a penalty tax that is $2,000 per year per full-time employee, excluding the first 30. You just can't make this stuff up. They give you a break on the first 30. All right? So it's interesting, if let's say you have 60 employees. Well, the break on the first 30 is a big deal, right? Cuts that 2,000 ahead into 1,000 ahead. If you have several hundred, several thousand employees, I'm not sure that break on the first 30 means much to you. But it's important depending on your employer size. Now, this tax is actually a monthly tax. We had somebody earlier mention I only employ them 7 months out of the year. You're only paying this tax for the months that you actually employ somebody as a full-time employee. So if you do the math, it's about $167 a month. So if you only employ somebody for 7 months out of the year, it's going to be 7 times 167. I'm not even going to try to do that. $1,200, something like that. But if you employed a full-time employee for the entire year, the penalty comes out to $2,000 per full-time employee. Now, technically, you will only pay this employee, or you will only pay this tax, if at least one of your employees goes out to the insurance exchanges that I mentioned earlier, or insurance marketplaces, and gets government subsidies to buy their coverage. You can rest assured that that will happen if you don't offer coverage, because the government subsidies under health care reform go all the way up to somebody with an income of 400% of the poverty level. So just to give you an example, you look at the federal poverty level today for a family of 4, it goes up to about $94,000 a year in annual income. So you could have an employee with a family of 4 making $90,000 a year, and they're going to qualify for government subsidized coverage under the health insurance exchange. So don't think of these subsidies as subsidies just for, lower income, indigent type folks. A big piece of the population is going to qualify for a subsidy. So you can rest assured that will happen. If you decide not to play, somebody's going to go do that. You're going to pay this tax of $2,000 per year. Now, there's another tax that you could be exposed to, and this is if you try to play, but you fall short somewhere. So you offer coverage to all your full-time employees and their dependents. It's minimum value coverage. You bought an insurance product that meets that 60% standard. But it turns out that for some segment of your workforce, the coverage isn't affordable. So most likely, your minimum wage folks. Maybe the way you priced your coverage, it turns out that some of your minimum wage folks or some of your lower income folks, they'd have to come out of pocket 12% for coverage. So if instead of buying your coverage, they go to the insurance marketplace, insurance exchange, and buy their coverage there and get a government subsidy because your coverage wasn't affordable, you're going to pay a tax of $3,000 a year for each person that actually goes out and gets that government subsidized coverage. And again, this is a monthly tax, so it's $250 a month for the months that you employ the people. You'll never pay more than that first tax, that $2,000 times every full-time employee less the first 30. So you know you're kind of capped out on a tax there. But you may pay this $3,000 tax. Now, I'll tell you, when I first started talking about this, I used to tell employers and clients, look, if you're going to play. Make sure your coverage meets the requirements. Don't spend all the time and energy and money putting in place coverage only to expose yourself to this $3,000 tax. Why would you do that? Make a choice. And by and large, I think that that's still true. But what I've seen recently in some of the complex planning that a lot of employers are doing, some employers are assuming they're going to pay this $3,000 tax for some segment of their workforce. Some employers are saying, look, I'm willing to take the risk that my lowest paid workforce, that some of those folks may actually go out and cost me this $3,000 penalty. But I'm okay with that because if I made my coverage cheap enough so that it was affordable for them, it would cost me more than $3,000 to subsidize their coverage, right? I mean, at the end of the day, it's just economics, right? Is it cheaper to pay this $3,000 penalty for some people, or is it cheaper to get your coverage low enough so that it's affordable for every single one in your workforce? So if you're sitting down and pushing around the numbers, it may very well be that it makes sense to assume, to build into your assumptions, because after all, this is all, you're just projecting, that some of your employees may cost you a little bit in this $3,000 penalty. Now let me get through some of the things on this slide, and then I'll stop and take some questions again. Every employer in this room, if they haven't already, needs to sit down and crunch the numbers on all of this. And we've worked with a lot of clients to do this. We've built the spreadsheets to kind of compare all of this. And there are some things that you want to keep in mind. It's really attractive to kind of throw up your hands and say, I'm just going to pay the penalty, $167 a month. If I do the math, it's going to cost me at least that to subsidize coverage for everybody. Well, keep this in mind. If you pay that penalty, you're paying it for every full-time head, no matter what, excluding the first 30, of course. But if you put coverage in place, even if it would cost you $180 a month, not every single person is going to take you up on it, right? Your obligation is just to offer the coverage, not necessarily to make sure they get it. So you take your pool, let's say you have 100 minimum wage employees who don't get coverage today. So, this is your problem. You're trying to figure out what are you going to do with these folks. Well, again, if you pay the penalty, you're going to pay it for every head. But if instead you offer coverage, and you can do it within your insurance policy, maybe 10 of them are going to take you up on it. All right? So you're only going to pay whatever that subsidy is for the 10 that actually take you up on the coverage. So keep that in mind when you're crunching the numbers. One of the big assumptions you're going to have to make, and it's difficult in your industry, is how many of these folks are actually going to take the coverage. You don't have any data to go on because they were never offered coverage before. So that's one of the big variables when you're sitting down crunching the numbers, is trying to estimate how many of these folks are going to take coverage who were never offered it before. Another something to keep in mind, the penalty tax is non-deductible. I love it when people laugh. It's non-deductible. Whereas, as I mentioned earlier, every dollar you spend subsidizing coverage is a tax-deductible compensation dollar if you're a for-profit tax-paying company, and I suspect most of the people in the room fall into that category. So when you're comparing the cost of playing versus the cost of paying, you need to make an adjustment to make sure you're comparing apples to apples. All right? You're going to lose your tax deduction, so maybe that $2,000 penalty looks a little bit more like a $3,000 or $3,500 penalty on a net tax basis. So keep that in mind. One more consideration. And this was a big surprise. When the IRS came out with its regs in January, they said, look, this choice to play versus pay can be made separately for each control group member. So we talked a lot earlier today about how you might have different companies. Maybe you have 5 separate companies. Even if they're all treated together for purposes of that 50 or more test, once you get past that and you're looking at how the mandate's going to affect each one, each company can decide separately whether it wants to pay the tax or provide the coverage. Now this is where it gets interesting, right? Maybe you've already done this. Maybe you have a particular segment of your workforce dropped into this kind of operating company, and you have another part of your workforce, maybe your corporate folks, in another company. If it made sense for you, perhaps you could decide to pay the tax for one and provide coverage for the other. In some cases, there might be a planning opportunity there for some employers, but this was a surprise because the way the law is written, it looks like it's an all or nothing proposition for the whole control group. The IRS has come out and said, nope, it's a separate decision for each. Now, I know what some of you are thinking. Hey, you get an exclusion on the first 30. I'm just going to set up a bunch of 30-person companies, right? They thought of that. The 30 exclusion basically gets allocated across the companies. So you can't use this rule to take advantage of multiple exclusions of 30. Doesn't work that way. All right, before I move on to the next topic, any questions? I know all of this is crystal clear, so shouldn't be a problem.
So for that $3,000 penalty, it's on the individual.
Oh, I'm so glad you asked that. When somebody goes to the exchange, how do they basically prove that your coverage is unaffordable? Let's talk about the mechanics of this, and the folks at MVP might have something to say about this later as well. But when somebody goes to an insurance exchange, anybody who wants to can buy coverage. The question is whether they'll get a government subsidy. They're going to fill out an extremely complex set of applications. We've seen some drafts out there on the internet thus far. And part of that is going to say, who do you work for? Do they offer coverage? How much do they charge you? And in theory, all the information that is necessary for the exchange to determine whether or not the coverage is affordable will be provided to the exchange. Because remember, you only get the subsidy if your employer's coverage is unaffordable. If your employer's coverage is affordable and you just decide, I'd rather buy it over here, you can buy it, but you're going to pay full boat for it. You're not going to get a government subsidy. So the exchanges will be basically analyzing this, and the theory is that if the exchange decides that a particular individual's coverage from their employer is unaffordable, the exchange is going to notify the employer of this determination, and the employer will be given an opportunity to respond. Because, I don't know, there might be a few people who provide bad information to the exchange, right? So the theory is, and again, we have to wait and see how this works, that basically you'll have an opportunity to respond to that so that you don't get exposed to this penalty. Now, that brings up another point, which is, when do I pay this penalty? Once a year, if you're a large employer, you're going to file a completely new tax return that we don't know what it looks like yet. That's going to be all the information the IRS needs to figure out whether you owe a penalty. How many employees did you employ each month? Did you offer coverage? How much did you charge? All that kind of stuff. And what we think is going to happen, and we don't know exactly yet because the regs haven't come out on this yet, is it's going to be an annual return that is filed after the end of the year. So we're going to get all the way through 2014, and sometime in the first quarter, most likely, you will file this additional tax return with the IRS. It will give the IRS all the information it needs to know whether you owe the penalty. The IRS will also take information from the exchanges about how many people got subsidies. And through that process, basically they will bill you for any penalty you owe, whether it's the $2,000 a year penalty or the $3,000 a year penalty. And what the IRS has said is that you will have an opportunity to appeal the determination there as well. So in theory, if everything works out, you'll have two opportunities to make it right, if you will. Once when the exchange tells you that somebody came to them and said the coverage was unaffordable, and once when the IRS tries to send you a bill for a penalty that you don't think you owe. That's how the process is going to work. Obviously, it's going to be a while before we know the details. The interesting thing about it is if you decide you're going to pay the penalty next year, you're probably not going to actually have to come out of pocket for it until mid-2015 at the earliest, right? Because you're going to have to get to the end of the year, submit your return, and then the IRS is going to have to bill you. So all of this is going to shake out, on a rolling basis after the fact. But again, don't shoot the messenger. That's how it's going to work. Question? Oh, great. Yeah. In trying to determine whether coverage is affordable, what about employees that get basically in-kind type compensation, housing, vehicles, things like that? Well, it's a household income standard or perhaps a W-2 income standard if you decide to make use of that. To the extent that any of those things are taxable and would show up as taxable income, a household income or W-2 Box 1 income, then yes, it will be taken into account. But it's a whole separate subject as to the extent to which those things are taxable, rightly or wrongly. But in theory, any benefit you provide, whether it's in kind or cash, is going to be taxable, and then we'll filter in there. But it's going to depend on what ends up being taxable.
On those 7-month employees, can they pay their annual premium in those 7 months when they're working? So not to chase
Yeah. What about the premiums? Yeah. Well, the way it's going to work, like it does today for most employers, is it's a monthly premium. So they're going to be paying their premiums on a monthly basis, just like employees would today. So I don't envision you being in a situation where you're chasing after an employee for 7 months of premium or 5 months of premium for the 5 months they weren't there. Remember, they're only going to get your coverage for the 7 months they're with you. Okay. Well, yeah, you'd offer them COBRA coverage, just like you do today, but put. Again, that's a whole separate story. All right, here's the deal. I have 5 minutes to power through some stuff that's important. Again, we'll have lots of time for questions, so everybody will get their questions answered today. Full-time status. Remember how I said it's a month-by-month determination? The IRS looked at that, again, because they feel for you. And they said, that's really not workable for employers, or employees for that matter. This idea that you could be full-time 1 month, part-time the next, right? And just kind of weave in and out of that status. Administratively, it's a nightmare. So they created, by regulation, something that is intended to kind of smooth out the full-time, part-time process. And this is an important thing for people in your industry. And this is not a new concept. I got to tell you, employers that have variable hour workforces have been doing this for years. This idea that you're going to measure somebody's hours over a particular period of time, a measurement period, a look-back period, and if they meet a certain average, then they'll be treated as full-time for some period of time after that. Very common practice that's been done for years in lots of industries. Nobody ever labeled it like the IRS has labeled it today. So the IRS has basically said that for what they call variable hour employees who are not reasonably likely to work at least 30 hours a week, I'll call those part-timers, and seasonal employees, regardless of how many hours a week they're going to work, you as the employer can measure their hours over what they call a look-back period or a measurement period to see whether or not, indeed, they average at least 30 hours a week and therefore qualify as full-time. And only if they qualify as full-time, because they work enough during this measurement period, would you then need to treat them as full-time. Now, this tool is not as useful a tool for employers who don't have seasonal workers. In an industry like yours, when you can apply this rule to every seasonal worker, this is going to be a big help for basically limiting the number of your seasonal workers who turn out to be full-time. So here's how it's going to work for new employees. Just, again, kind of big picture. You hire a new employee starting next year. You're going to have to put them in one of three buckets. They're full-time, meaning they're going to work at least 30 hours a week. They're part-time, not likely to work at least 30 hours a week. Or they're seasonal. And if they're seasonal, doesn't matter how much you intend they're going to work. They're going to go in the seasonal bucket. If somebody's a non-seasonal full-time employee, you hire a new corporate staff person and you plug them into a full-time position, you're not going to measure their hours over any period of time. The law says that you can't, starting next year, you can't impose any more than a 90-day waiting period for your plan. So if somebody falls into that full-time bucket, you're going to hire them, and then no later than 90 days later, you're going to need to offer them coverage. And what the IRS has said is during the first 3 months of their employment, which corresponds with this 90-day waiting period, you won't have to worry about paying a penalty for a full-time employee. All right, so that kind of matches up. For everybody else, your part-timers and your seasonals, you get to apply this measurement period before they would qualify as full-time. So let's talk about how this would work. The measurement period for a new employee, which will be measured from their start date, is a period of anywhere from 3 to 12 months. You get to designate it. Now, I can tell you that most people in your industry, most people in any industry, are going to use 12 months, right? Why not use the longest measurement period possible? Because then you can keep people out of full-time status for that full 12-month measurement period. Plus, you have seasonal people. They work for you for 7 months, then they come back. Well, guess what? The 5 months they're gone goes into the average. So if you can measure people's hours over that longest measurement period, it's going to allow you to manage how many people actually hit that 30-hour average during the 12-month period. This is what most of you are going to use to try to limit the number of your people that are going to qualify as full-time employees. So let's say you use a 12-month period. You hire somebody, you're going to measure their hours basically to their anniversary. If they meet the 30-hour standard, you would then treat them as a full-time employee for the next 12 months that follow. And this is what they call a stability period. Basically, they made the cut, so then you have to treat them as a full-time employee during the stability period for the next 12 months. Likewise, if they don't make the cut, you don't have to treat them as a full-time employee for the full next 12 months. All of this is regardless of what their hours actually end up looking like during that 12-month stability period. Okay? So, what you're going to do is you're going to sit down and look at your workforce and the seasonal staffing needs, and you're going to have to figure out what makes the most sense. Should I use a 12-month measurement period? Should I use a 6-month period? If I average people's hours over these periods, how is it going to shake out? How many of them are going to reach the end and actually qualify as full-time, 30 or more hours per week? This is going to be an important tool for you to use to figure out who you're going to have this obligation for. All right? You can talk about affordability all you want, but what matters most is for who, right? You have to figure out who's full-time. And you don't have to do that month-by-month determination. You could if you wanted to, but this will be helpful for a lot of employers. You're also going to have, for what they call your ongoing employees, your stable workforce, a standard measurement period, stability period. So what a lot of employers will do is, you have a calendar plan year. That calendar year is your stability period, and you have a measurement period that's sort of offset from that. Maybe it's 11/1 to 10/31. Then you run the numbers. You see who made the 30-hour average for the year. They're full-time for the next calendar year. Those who didn't make the average are not full-time for the next calendar year. Basically, though, you can employ this to determine who's full-time and who's part-time for all purposes, even if you're paying the tax. Okay? So if you decide to pay that penalty tax, you still have this ability to kind of manage who's going to qualify as full-time or part-time under the rules. Now, it's complex, more complex than it ought to be perhaps, but it's going to be a useful tool for everybody. A couple of things, I'm running late here, sorry, that I want to mention that kind of run alongside this employer mandate that I want to just make sure everybody's aware of. These are things that are not effective yet, but as soon as the government comes out with regulations, they will be. One of those is what they call automatic enrollment. If you're 200 or more full-time employees, as soon as IRS comes out, as soon as DOL comes out with regulations, you will have to change the way you enroll people in your health plans so that the default is as soon as they qualify, they're enrolled unless they opt out. Right now, what happens is an employee comes to work for you. If they meet the requirements, you give them some paperwork and you say, sign up if you want the coverage. You will flip it. And you'll say, here's the paperwork. Either opt out or we're going to put you in. That's what automatic enrollment is. Study after study shows that this will increase your participation. The same people who are too lazy to fill out the paperwork to sign up will be too lazy to fill out the paperwork to opt out. It's just study after study shows it. It boggles my mind, but it will happen. That's why I want to mention it. If you fall into this 200 or more category, this is going to be one of those things that's going to increase the amount of employees taking your coverage in the future, which means it'll increase your costs. Last but not least, non-discrimination requirements. And what I'm talking about here is discrimination between highly paid people and non-highly paid people. The type of discrimination that I call tax code type discrimination that you deal with like with your 401k plan or your retirement plan if you have those types of things. As soon as IRS comes out with regulations, you will not be able to discriminate in your group health plan in favor of highly paid people. Meaning, you can't offer highly paid people better plans that you don't offer to everybody else. You can't offer them higher subsidies that you don't offer everybody else. You can't offer them a better eligibility period. Where this will come into play for most of you is in the subsidy. I have a lot of clients, particularly in your industry, where the corporate staff people, they just get coverage. They don't pay anything for it. Or if they do pay, it's not a lot. But everybody else, you offer them coverage and they have to pay a substantial amount if they want to buy it. That's the type of thing that will probably no longer fly when these non-discrimination rules come out. You will basically have to gravitate towards providing the same deal to every employee, regardless of whether they're management or a field worker. Now, there's a workaround, right? If your management employees aren't paying anything now, you can always just increase their pay and then charge them, and then it's net break even, right, to them. So that's the workaround. But if today you're not charging your managements or your executive folks, that's probably going to have to change at some point in the future. You don't have to change it just yet, but when these rules come out, probably sometime in the next 9 to 12 months, you will, in all likelihood, have to change the way you're doing that in order to meet these rules. Okay, so what should you be doing now? Well, obviously, you have to determine whether the mandate applies, right? That's step one. And I know there's a lot of people in this room that have multiple operating companies and all sorts of creative things going on where this is going to be an interesting analysis for them. So make sure you do step one. Take a look at that seasonal worker exception. If you know you're going to be subject to the mandate and you have not sat down already and run the numbers, you need to do it. Some of the most interesting analysis that I've seen is in your industry, where somebody sits down and takes this huge segment of workers that have never been offered coverage before and figures out what would my cost be if 10% of them sign up? What would my cost be if I had to pay the penalty? And I've seen some big surprises, the erasing of thin margin surprises. Okay, so if you haven't done it already, you need to sit down and run the numbers. Again, we've sat down with a lot of clients and built the spreadsheets and done that. It's very important because you only have 7 months to figure it out now, 7 or 8 months. The look back and stability periods that I mentioned at the end about figuring out who's full-time, you got to figure out what's going to make sense for your business. If your goal is to minimize the number of people who qualify as full-time, then you need to figure out what's going to work best for that. A 9-month measurement, a 12-month, a 6-month. When should it run? You know, in your industry where you bulk up during certain times of the year, the designated period that might run for your regular workforce could make a difference on who qualifies for full-time or part-time. So that's going to be important as well. And that's something you're going to have to write down somewhere. Okay, you're going to have to be able to prove this is the system we were using, either for eligibility in our plan or for purposes of determining who is full-time for purposes of paying the tax. So make sure that you sit down and think about this look-back stability period and what makes the most sense. And then follow developments in the law. I mean, I'll tell you, having spoken to a lot of groups like this over the last 3 years, I've spent a lot of time telling people, we don't know the answer to that yet. We don't have the guidance. In January, when IRS came out with all the regs, it answered a lot of questions. Okay, a lot of the stuff I've told you today, we really didn't know what the answer was until January. But there's still a lot of developments in the law to come. I mentioned 2 of the big ones today, this automatic enrollment, the non-discrimination rules. You need to keep your eye out for those things because they are also going to impact your business and the way your plans work. And then I know the folks at MVP are probably going to talk about some of the other moving targets in the law today when it comes to the exchanges and some of the other stuff. So definitely keep your eye out. Again, we'll take questions throughout the day. I'm sorry I didn't get to everyone's questions. I appreciate your attention today, and I look forward to speaking with some of you as the day progresses.